Hello, everyone. Welcome to Courageous Custody, your weekly dose of empowerment and practical guidance. I am Renee Rodriguez, creator of The Custody Blueprint, divorce mediator, and parenting coordinator.
And I am Atra Tarfa, level 3 trained internal family systems practitioner and co-founder of the Global Trauma Institute. And what Renee and I are here every week doing is equipping you with the strategic thinking and emotional support that you need to navigate the difficult journey of having unique challenges as protective parents in the courtroom. So we want you to do this with strength and resilience.
Yeah, so every Thursday at 7 p.m. Eastern, we're going to go live on YouTube, Instagram, and Facebook, bringing you inspiration and insight from stories about courageous parents who have walked in your shoes and emerged victorious in big ways and small, and practical strategies from us to help you advocate for your children and manage your trauma as you go through your custody case. So let's dive in.
Let's do that.
Just a reminder that we are not giving legal advice or therapy.
Yes, and if you're feeling triggered, please take care of yourself.
So today's topic is when your child's voice is ignored, how to ensure their wishes are heard in family court as we continue with Child Abuse Awareness Month and talking about, how the children fit into these custody cases. We want to talk a little bit about that today. We had talked, I think, a little bit a couple of episodes ago about what age courts start listening to kids. And for those of you who missed it, jump into that. But otherwise, it's important to know that it's usually when they're a little bit older, like between 12 and 14. I have certainly had protective parents whose kids, were 11 and their voices were heard, but usually it's 12 or 14 is a number that we hear quite a bit. Now, there are plenty of jurisdictions, as mentioned before, that have no ages and they don't even like to consider children's voices at all. So it's important to figure out, go to your state or province, figure out what in my area is the age at which the family court starts listening to children's wishes, right? Now, the question becomes, how do we introduce a child's voice without putting them in the middle? And that is really a delicate balance. We want to ensure that their wishes are heard, but we absolutely do not want to burden them with the stress of making adult decisions. I have a lot of parents who are saying, well, as long as my child is telling the truth and it's okay and honesty is important and they should be able to speak up. And certainly all of those things are true, but it's huge. And when we hear adult children talk about this, it is a difficult thing for them to be thrust in the middle of. But, they can do written statements or affidavits, and that can be prepared with the help of an attorney, a child attorney, or a child therapist. And those statements can express the child's preferences without requiring them to testify in court. And another way is to provide evidence of the child's feelings through documentation of their behavior or statements they might have made to trusted adults, like a therapist, right? Like the attorney for the children, the child's attorney, the friend of the court. That's another place. Maybe something that they said to a teacher or some other trusted adult, right? And, we should talk about, along that same vein, guardians ad litem and child interviews. Guardian ad litem, a GAL, is a court-appointed advocate for the child. And there's lots of different names for this, depending on where you're at in the world. It could be Minors Council, it could be AFC, it could be FOC. There's a lot of different names for this, right? But essentially what they do is they'll conduct investigations. They're going to interview the kiddos and they're going to come back and they're going to make recommendations to the court. Some of them are more focused on, looking at the whole case and believing what they think, should happen. right? Which is going to maybe or maybe not have the child's voice as part of it, the child's wishes as part of it. And others, like an attorney for the court, I'm sorry, attorney for the child, an AFC, for example, or any position like that, is entirely going by the child's wishes. And of course, there are pros to cons to that as well. So the interviews that all of these professionals are doing with the children is a good way for the child's voice to be heard. But one of the things you have to consider is that you have to prepare your child for that process, right? You have to explain to them, here's what to expect. And maybe you're working with that child's professional to determine what is it that you're going to ask them? Is there, what can you share with me? What would you like me to say to my children so that they understand how to prepare for this, what to expect, right? And I think it's just crucial, absolutely crucial, to tell your child that they can be honest and open with the guardian ad litem, right? It's important also to remember that, as I've talked about, not all guardians ad litem are created equal. So you need to research your guardian ad litem and see if they're trauma informed, see who's worked with them before, and see who has a sense of what they're like. And I think, one thing that comes up every once in a while, but that most protective parents don't think about, is to consider the power of a child journal. This is something that some people feel, we have to consider, some people feel like the worst thing you can do is use a child's journal in a custody case. And then there are others who kind of feel like, well, wait a minute, the child is actually talking about their wishes in this journal. This is an opportunity for the court to understand that without any coercion, right? So it can be, a child's journal can be a valuable tool for sort of documenting your child's thoughts and feelings and experiences. And I love to see drawings, right? Atra, like we've heard our clients say, something they presented in school to the teacher, anything like that. Those kinds of things can be very telling. I can't tell you how common it is for our parents to have their children, when they're making like a Father's Day, Mother's Day, when they're making a card for a holiday or for an abusive parent's birthday, their real feelings come out right there in front of the teacher. I've seen a lot of things, these forms that in school they might have them fill out and say, hey, write all the good things about your parent that you love. And they're kind of like, yeah, nothing. And they actually write it there. And it starts to become, well, is this alienation or what is this? But when it's right there in the school, one has to sort of take that as something that the court should be aware of. And that could be a way to show the child's wishes, their preferences, or any concerns, because it's important that the child feels safe and, supported throughout this whole thing. So they should be able to write and draw anything that they want. And they should know that their journal is going to be kept confidential unless they choose to share it. But many children do want to share it. They do show it to the protective parent and say, hey, I wrote this, because they're looking for help through it. But the court system is sort of help through it to make sure that these children end up being parented primarily by the safer parent rather than the abusive parent.
That is the hope, right? With the family court, going back to the family court really sort of being this legal system that prioritizes stability and neutrality over hearing the child's experience or hearing the emotional piece, because, it just happens. And here's why this happens and what protective parents can really do about that. Again, courts having these, as I call these manager parts that prioritize order and evidence over truth. What truth is what evidence you can produce and what narrative is attached to that evidence. And many family courts operate with these protector parts that focus on keeping the system running efficiently rather than deeply listening to what the child has to say or what the person who's been in an abusive situation, the actual trauma survivor and abuse survivor, has to say. So legal professionals often believe that encouraging children to express a preference will cause them more distress, leading courts to silence the children rather than help them process their experiences. And there's this widespread belief that shared parenting, meaning courts tend to dismiss a child's request to limit contact with an abusive or unsafe parent as mere, oh, that's just the other parent coaching or the other parent's influence, or parental alienation being done, when in actuality, it may just be that child actually feels unsafe with this other parent. Many judges or custody evaluators or attorneys have these parts that, again, they prioritize that neutrality, but they also have these parts. The legal system, in a sense, has this sort of firefighter response to high conflict cases. They just want to shut down that complexity rather than engaging with that complexity, because again, that doesn't lend to the order, right? We have a hearing at this time, we have this being presented, depositions at this time, and it's up to that's for the lawyers to deal excuse me, for the lawyers to deal with their clients. We don't have time for that emotional stuff here, and that can lead to this quick dismissal of even a child's real concern. So some professionals, again, like I've said before, may have their own parts inside that make it really difficult for them to process. Maybe they've had their own childhood experiences. And not to say that that can't come up, but there is a reality here that there are biases that do exist. And having an awareness of these biases and accepting that they are there is going to help when you plan for your strategies. And it's going to help maybe understand, oh, that might be why this child's voice is being dismissed, because they're out to protect themselves and minimize what the child is saying. So again, children also who speak out in emotionally dysregulated ways, whether it's anger or withdrawal or anxiety, those children are often seen as problematic, right? As unreliable, as non-compliant, while the comparent, who actually may be the unsafe one, appears more stable. And because the court rationalizes, or the court favors rational presentations, even though children who have experienced trauma may struggle to communicate in the ways that the court understands. And having an expectation of a child to communicate fully what they're feeling and expressing, instead of actually being quiet, more leaning towards quiet, more leaning towards anger, more leaning towards withdrawal or anxiety, there's going to be a dismissive of that.
Yeah.
And so I really think that it's important for us to, understand that a lot of legal professionals may not listen. They'll find that guardian ad litem or the child psychologist or the evaluator. Hopefully, it's going to be someone who is trauma informed and can frame the child's concerns in a way that the court understands. And that is the way that the child will be able to be heard. Hopefully, that's the hope.
Yeah, and I mean, we do see that from time to time. So there is reason for hope, but it really does come down to how things are being presented, from
Absolutely.
the way we're presenting ourselves as well as what we're presenting, right?
Yep, that is exactly it. It's the evidence and then the narrative that's created around that evidence, which is what that strategy and why that strategy is so important. But it's no surprise that voices are dismissed at all.
No surprise, unfortunately. Yeah.
Yeah.
Well, that's all for this week's episode of Courageous Custody. But before we go, thank you so much for joining us, whether live or on replay. We're so grateful to have helped in any way that we may have. We have some great takeaways for this week. Understand the court's perspective on a child's voice. Find ways to introduce your child's voice without direct court involvement, and utilize tools like the guardian's ad litem, the GALs, and also possibly child journals, drawings, etc. effectively.
Yes, next week, join us again, 7 p.m. Eastern here. Like or follow us or bookmark us so that you can get the notifications and not miss a thing, because what we're talking about might catch you just when you need it.
So leave your own comments below. And wherever you're listening, remember, you're not alone. Until next week, stay strong, stay informed, and keep fighting for what matters most. Bye-bye, everyone.
Bye, everyone.